Welcome to this fourth webinar on detention and deportation. I am Elena Olea from Alianza Americas, and I am really very happy and honored to be moderating the conversation today. The effort to convene these webinars is a joint collaboration to try to spark and begin broad, bold conversations on what we believe are main topics of the agenda of migrant organizations worldwide. After the Global Forum on Migration and Development, civil society identified a number of priorities, and we thought that it was timely that we begin having these broad conversations on some of these topics. And probably the pandemic has also created specific conditions where we have had to spend much more time at home than what we would hope we would, and that definitely is a privilege in no means, but it has also perhaps allowed us to think deeper about issues that we are frustrated with the path moving forward, the pace at which things are changing, and so we thought that it was timely and important to have these conversations. Specifically on this topic of detention and deportation, we were very much inspired by a webinar series that we had on December 18 of last year on International Migrants Day. And some of you may remember this long marathon of webinars, one topic after the other. They were all very inspiring, very energetic. And there was one on detention. And so some of the panelists that we have today were participating in that panel. And if you were there, either because you listened or you were one of the panelists in that day, I'm sure that you will be happy to know that that conversation that we began that day was kind of what we're trying to follow today, because we believe that this is an important topic. I also would like to present some broad concerns that we have. We are concerned with the normalization of detention and deportation as standard policy solutions to address immigration. And this, regardless of whether irregular migration is criminalized or not, women, men, and children are being deprived of their liberty as a result of their status. And in many cases, that deprivation of liberty is what happens before they are actually deported. Detention is the prelude to an administrative determination on deportation or to their release, and an opportunity to continue seeking legal status or a relief from deportation. We are concerned with the fact that detention is being used as a deterrent of irregular immigration. It's a form of punishment. But as I said, it has also become the standard policy solution with almost non-existent or watered down due process standards. In most countries, individuals who are under immigration detention do not have the right to an attorney paid by the state. In most cases, they really struggle even to try to make contact with an attorney outside who could represent them if they had the means or were able to pay for one. There is no such thing as a public defender in immigration detention. Another important consideration is that in many countries, immigration detention is not reviewed by a judge. The decision to maintain a person deprived of their freedom is not reviewed by a judge. And thirdly, detention conditions are a matter of great concern. They are appalling in many parts of the world. Also, in the case of deportation, we are very much concerned that that has become the standard solution, that we are failing to address the trauma and the pain caused by deportation. We're failing to understand that families are being separated in the context of deportation, and the impact that deportations have also on the rights of children, for instance, who have to grow with their parents living in another country. So we also believe that it was important to discuss this topic because in many ways we are, and I think this is a collective frustration with the standards set forth in the Global Compact on Migration. Many of us who participated in the negotiations or who were following the process from afar were certainly hoping that the standards set forth there would be different. And so we believe that it's necessary to discuss the strategies and the work that is being done on the ground to address detention and deportation, to hear from your experience, your voice, the work you're doing in terms of what is working and what is also not working. And we want to invite you to come with bold, broad proposals to the table, to share with us what you have, the challenges, but also the bold ideas and the dreams you have and the strategies that you are seeing moving forward, because this is how we think we need to start moving the conversation in this aspect. There are a number of topics that we hope to address today, and we try to convene a diverse panel that try to find regional balances and gender balances, and that definitely is challenging. And I want to thank the 5 panelists who are here with us today. We hope to have a rich and lively discussion on this topic. And the first thing I would like to do is to introduce our panelists today. We have Michael Flynn, who's the Executive Director of the Global Detention Project that's based in Geneva, Switzerland. I am going to read your bios very briefly because I really want to get to the discussion, but let me just mention that Michael is a co-author of a number of books. He has been working in other organizations, and from his background, he holds a BA in philosophy and a PhD in international studies. Our second speaker is Sumita Shantini Krishna. Sumita, and if I did not pronounce your last name correctly, please correct me now. I did, thank you. She's the founder and director of Our Journey, which is an NGO platform in Malaysia advocating for the development of supportive migration systems for non-citizens. Sumita also works as a practicing attorney, and she has her own practice. And she has been working in this topic for over a decade. She is the chairperson of Migrant Forum Asia. Welcome, Sumita. Our third participant today is Pablo Seriani Cernadas. Pablo is a lawyer from Argentina, from La UBA, and he also has a PhD in human rights from the University of Valencia in Spain. Pablo is the coordinator of the Migration and Asylum Research and Advocacy Program at the Institute for Justice and Human Rights of the National University of Lanús, Argentina. That is a very long title, Pablo, I have to say. Pablo has worked as a consultant for a number of organizations and is an advisory board member as well of a number of other organizations. Marta Gyonko has been working in PICUM. She previously worked for the ILO and for the World Organization Against Torture. Marta has a master's in law and an MSc in migration, mobility, and development. Welcome, Marta, today. And our last panelist is Wayne Nicube. Wayne, did I pronounce your last name properly or not? If not, please correct me. Okay, thank you. Wayne is a public interest litigator who has been working for the same organization, Lawyers for Human Rights in South Africa, for the past 10 years. Wayne began his career as an intern and was recently appointed the National Director of Lawyers for Human Rights. He has worked, of course, in impact litigation, in coalition building and mobilization, and he has also authored a number of publications. Wayne has a Master's of Law in Human Rights Advocacy and Litigation from the University of Witwatersrand. Welcome to all of you. We're really happy that you're here today, and we want to thank you for your participation. Thinking of the order of the discussion, it seemed fit to start with Mike, so that, Michael, we can start broadly, from your global perspective, and then we may move to what's happening in different regions with the rest of the panelists. And then in the next round of questions, I promise to move around, and you will not be the first, but I think it would be a good way to move forward. I want to invite the audience, if you have any questions, to begin posting them on the chat so that we can have a lively exchange. Also, often the audience shares resources, or other materials, and I think that that's part of the lively conversation that we're hoping to have here today. So, bearing that in mind, I would like to welcome you all. And Mike, to start with you. And I want to start with a difficult question, which is it possible to have a global civil society advocacy strategy on detention? And if it is possible, what does that strategy look like? Welcome, Mike.
Thank you very much. Thank you for the introduction, and thank you for the invitation to be here for this conversation. And as ever, it's very nice to see some familiar faces around the table. So the question, as you rightly note, is not an easy one. But the reason why I think it's an important one is because when we look at the compact and we look at how it addresses immigration detention, there's a lot of good things in there, and there's a lot on human rights. And yet, when it discusses how we should be addressing immigration detention, it very quickly moves to, in fact, in the title of the Objective 13, it moves directly towards a particular kind of campaign, which alternatives to detention. And for me, it's always been a little, I wasn't involved in the negotiations. I wasn't involved in the civil society organizing that was behind all the action that was going on behind the compact in those days. So I don't know how, what happened, how this came together exactly, but it always struck me that this was a bit of an odd move to make, because it seemed as if the compact is proposing a one-size-fits-all solution to a problem that, as everyone around this table surely knows, is not one size, right? I mean, to go from Europe to South Africa to Latin America to Malaysia and every place in between, we realize that this is a very, very complex issue. And in fact, in some ways, it's hard to compare it at all. Elena, I would remark, for instance, on the idea that immigration detention is merely an administrative procedure. Today, we were trying to work on Zambia and what's going on in Zambia. And in Zambia, they keep putting out press releases about how they are prosecuting people for crossing into the country and being there illegally. And what is the crime? What is the punishment? The punishment is some fairly large fee that you have to pay once you're found guilty. And if you can't pay it, 1 year hard labor in prison, right? So this is a far cry from an administrative procedure, right? This is outright punishment, but that's an immigration detention in Zambia. So it's really important to note that when we think about this issue, it's so heterogeneous. And this raises these questions. Why propose something such as a campaign for this kind of a phenomena? And I was involved in that meeting back in December, and I remember fondly the conversation, and I remember also William asking a very tough question, which I was unable to answer at that time, which was, so what do we do? How do we build constructively on an analysis of whether or not ATDs work or not as a global campaign? And I've been with that question since then, thinking about what would something like this look like? And so I'm not going to speak. I think I have 3 minutes, right? So what I want to propose, instead of going into the critique that I have of ATDs, I'll share something on the chat in a little bit that is a brief kind of critique or assessment of some of the concerns about how ATDs are promoted. And it concerns the Committee on Migrant Workers General Comment number 5, which should be released any day now. And we outline the GDP, some of our concerns and some things that we think we should do to build. So I'll share that so people can read more about that. But just to keep this conversation going forward, if ATDs as a concept can't fit globally, is there some other way to look at this? And so I think we should just look right at the opening paragraph, Objective 13, paragraph 29 of the compact. It ends with this sentence: we further commit to prioritize non-custodial alternatives to detention that are in line with international law and that take a human rights-based approach to any detention of migrants. I would suggest that another way to phrase that would have been, we recognize the primacy of the right to liberty. Now, obviously, this is a political document, and that is a very difficult statement to get in there. But I nevertheless think that when we think about a global strategy trying to roll back detention, we should focus on that the right to liberty is not an alternative, it is inherent, right? And so when we look from country to country and place to place, what seems to work, we really need to look at what are the threats to the right to liberty in those countries, and what are the opportunities that each country situation presents with respect to addressing those gaps and problems. In some cases, ATDs will work, I think, really well, but ATDs understood as a mechanism for challenging whether or not, or for testing whether or not every detention measure is necessary and proportionate. When we see, for instance, detention regimes that have mandatory detention provisions, ATDs seem to really take on a lot of importance. But then when you go to other places in the world where there's a lot of discretion on whether or not detention is being implemented, it seems to me that ATDs aren't necessarily the right tool there, but other potential avenues. And so what would those avenues be? And so I thought that, and I'll wrap up with this, I thought I'd just put together a list of, say, some outline questions that we should address for each country that we look at before we decide what is the best approach. This doesn't get us to a global approach, because I really don't have that, but I do think it gets us to a framework for how we may want to think about advocacy on this issue. So first of all, I think we need to ask, does the country apply immigration detention measures? And if it does, in what context? Is it part of an administrative context? Is it a criminal procedure? Or is it completely ad hoc? And if it doesn't, why doesn't it? Okay, question 1. Question 2, does the country have laws that prohibit any specific group of people from being detained? Because that is a wedge. If there is any prohibition in a legal system, then it's very important to see that and to clearly identify that, because that can become a kind of a leading issue. Question 3, is the country primarily a source, transit, or destination country? And why is this important? Well, this is important, particularly in the context of transit countries or countries that have mixed migration phenomena, because whether or not alternatives are going to work realistically are going to depend on where that country is in the migration phenomena. So we should know that. We should have that as part of our kind of questions, sets of questions. And then number 4, does the country have a time limit for detention procedures? Because if it does have a time limit, then that also raises the question of, are we thinking to, in the context of COVID, for instance, this becomes a very relevant question, because we saw this effort to promote ATDs in countries where there were strict time limits and people had to be released because there was no way, according to the regulatory framework in that country, they could keep a person in detention if they could not move towards a resolution of that case. And so that time limit to the procedure became very important. When a country looked up and said, well, we can't deport someone in this time because borders have been closed, well, we have to release them. That doesn't seem to me to be a context for ATDs. This seems to me to be a context of understanding very clearly that a country has a need, because of its regulatory framework, to release these people. And when it does so, there should be some effort to assist them. That is not about continuing their procedure through some kind of ATD framework, but rather, how can we help them? Now, and then another question, I already brought this up earlier, does it have a mandatory detention policies or is it discretionary in nature? And that's often not a very clear-cut question or answer. And then finally, what is the current regulatory framework in each country for testing the necessity and proportionality of detention decisions? What is it? How does it work? What is the mechanism precisely? Do we know it? And how are we going to build a advocacy campaign on emphasizing that part of the procedure? And then I think we can start to have a more sophisticated, complex vision of what we mean by immigration detention advocacy on a global level. I'll end my comments there. Thank you.
Thank you, Michael. You definitely have been very provocative, and we can already see the exchange on the chat. And I think that that is certainly a very good way to begin this conversation. And we will go back to it, and perhaps that part that you omitted, we can address it in the next round. Sumita, I would like now to go to you and to ask you about the situation in Malaysia and the work that you are doing. What can you share with us in terms of the strategies related to immigration detention?
Thank you, Helena. So let me just start off by saying that you have put in perspective a very good point about the detention of migrants and the element of criminalization. So one of the concerns that I have with detention of migrants is the criminalization of labor migration. So, but I think we need to ask ourselves as advocates, are we asking enough questions to the government on why migrant workers are being detained for violation of an administrative law? In a system where a migrant is dependent on an employer or an agent to remain documented, why must a migrant pay the ultimate price? So I think we are not challenging the government enough to decriminalize labor migration. And for that, one way forward would be for us to use the judiciary more actively to challenge detention procedures, example, focusing on bail, remedies for unlawful detention, addressing obstacles to allow migrants to remain in the country. And just addressing the question you asked me, let me share you a case that just happened last month of a Nigerian man married to a Malaysian, and he was detained for drink driving on March 15, and he served a day's jail and paid a fine for that offense. So he had a valid spousal visa until 2022, but he was detained thereafter for a total of 39 days without a valid court document, or rather without a valid court order, and his spousal visa was also cancelled. So this organization called Family Frontiers, they took on the case with the assistance of a lawyer, and he was able to secure his release. So the court held that his detention was unlawful. But in this case, thankfully, there was a civil society and a lawyer that was able to help. But unfortunately, in Malaysia, many migrants are not that lucky. So they spend a long time in jail, unlawfully detained, without having the prospects of also leaving. So sometimes the detention can be prolonged because, especially now, because of the COVID, we have seen a lot of migrants staying in prisons and staying in jail because they're not able to go back to the country of origin. So this is some of the things that are not, these are things that we are trying to address in Malaysia at the moment. So this case, I think, has paved the way for us to move forward with challenging some of the unlawful detentions that we have in Malaysia. So let me stop here, Elena.
Thank you, Sumita. I think that, yeah, definitely litigation and impact litigation can lead away. And that is usually a strategy, and we're going to see and perhaps have the chance of comparing how that strategy works in some contexts, and what possibilities and paths they open, and also what challenges also it brings to those doing detention. And now I would like to move to Latin America with Pablo. And let me remind everyone that which I didn't do in the beginning, but I think it's important that we have interpretation right there. We're trying to make this truly a global space as much as we can afford. We wish we had more resources and were able to bring in more languages, but there's interpretation to French, Spanish, and Arabic. And I would like also to take at this moment the opportunity to confess that I also was wondering whether I should have done the introduction in Spanish or not, which is my mother tongue, and clearly the one that I feel more comfortable in. And so when we were talking to Pablo about it, I thought that it would be a good idea if he speaks in Spanish, so that we also bring these global voices and these global perspectives to the table. So if you need interpretation, this would be a good moment to find the bottom down there, the little globe, and change to Spanish so that you can hear Pablo. And I would like to take the opportunity then to also ask the question to Pablo in Spanish. Pablo, sin duda, América Latina es una región muy interesante porque utiliza menos la detención migratoria que otras regiones, pero tiene desafíos importantes en materia de deportaciones, algunos que se han agravado, yo diría, en el contexto de la pandemia, desafortunadamente. Entonces yo quisiera preguntarte si podrías por lo menos presentar un panorama general de las tendencias y los retos en materia de detención, si te parece, y después podemos volver a la deportación en el próximo espacio.
Sí, muy bien. Bueno, muchas gracias, Elena, y gracias por la invitación. Es un placer compartir este diálogo con mis colegas. En América Latina diría que en general hay dos tendencias principales que se pueden clasificar en términos geográficos. La primera tiene que ver con la tendencia en Centro y Norteamérica, y principalmente a lo largo de lo que es la ruta migratoria a través de México o hacia México, pero principalmente hacia Estados Unidos a través de territorio mexicano. Y en ese contexto la tendencia ya hace bastante tiempo, hace muchos años, viene siendo una política de detención administrativa sistemática y generalizada de migrantes y solicitantes de asilo, incluyendo niños y familias. Y esa práctica es un elemento central de la política de control de la movilidad humana, principalmente de la política de Estados Unidos, pero con un rol muy importante por parte de México, ¿no? en esa política de intentar reducir o controlar la movilidad hacia el país norteamericano. En este contexto hay un desafío de índole estructural, que tiene dos elementos. El primero, las causas estructurales de desplazamiento de la población de diferentes países de la región, pero principalmente de algunos países centroamericanos, como Honduras, Guatemala, El Salvador, pero también de otros países del Caribe, de Haití, o de Sudamérica, de Venezuela, por ejemplo, pero de otros países, o incluso ingresando a Latinoamérica desde Asia o África para emprender el camino hacia el norte. Hay un problema estructural en esas causas de movilidad y que solo se pueden desarrollar de manera irregular porque no hay canales regulares para hacerlo. Y luego la cuestión estructural en la detención, que es el elemento operativo de una política de movilidad humana centrada desde un enfoque de seguridad nacional y orden público. En ese contexto, el desafío ha estado un poco siguiendo lo que decía Mike, en tratar de crear alternativas a la detención, y creo que hay que ir un poco más allá. Incluso el Comité de Trabajadores Migrantes a México hace unos años recomendó, por ejemplo, en el caso de niños y familias, la erradicación absoluta e inmediata de toda forma de privación de libertad por motivos migratorios, y elaborar de manera urgente toda una política que transforme estructuralmente este tema y que, por el cual la restricción a la libertad sea una medida de absoluta excepción. La otra tendencia es la de Sudamérica. En líneas generales, en los últimos 20 años, la tendencia ha sido no usar en modo alguno la detención migratoria, ir eliminando del marco normativo o de la política el uso de la detención. Se cerraron los poquísimos centros de detención que existían en la región, como por ejemplo en el caso de Ecuador, en el año 2017, en línea con reformas progresivas de la legislación migratoria en muchos países, la implementación de programas extraordinarios de regularización y de la creación de canales permanentes de acceso a la regularización, como respuesta en muchos países principal, prioritaria y obligatoria ante la irregularidad migratoria. No de sanción, sino de solución. De todas maneras, en los últimos años ha habido retos, incluso retos inéditos. En Sudamérica se han desplazado más de 4 millones de personas venezolanas hacia otro país sudamericano. Aún así, en ese contexto, no se crearon centros de detención y no hubo ninguna respuesta sistemática o generalizada de detención. Ahora bien, sí ha habido casos en los últimos tiempos excepcionales, pero preocupantes, desde países que implementaron medidas de detención de manera más estable, como Trinidad y Tobago, un nuevo país receptor en el Caribe, de población desplazada de Venezuela concretamente, pero también prácticas concretas. Hace poco tiempo el Comité de Trabajadores Migrantes cuestionó detenciones y luego expulsiones colectivas en Chile, por ejemplo. Otro reto reciente, la militarización de algunas fronteras, con el discurso un poco de control migratorio, pero también de la emergencia sanitaria, pero preocupante como respuesta desde las Fuerzas Armadas en lugar de lo que dicen las políticas y la legislación de la región, que es otro tipo de respuesta. Y como último desafío, que luego podemos ahondar, en contexto, un escenario actual de falta de consenso entre los estados de la región, no solo en el tema migratorio, muchos otros, pero sí es un giro negativo respecto de las 2 primeras décadas de este siglo, donde esta idea o este principio de no detención, de la migración como un derecho, de la regularización como respuesta, habían sido una de las bases consensuadas por todos los estados de la región como respuesta a la migración entre los países de la región. Muchas gracias.
Gracias, Pablo. Creo que nos quedamos con la duda de qué pasó, digamos, cómo entender este giro en Sudamérica, y ojalá podamos discutirlo más adelante. Now, I would like to move to Marta. And again, we are moving from one region to another, and we're also, and we are very mindful of this, we left some regions out. We didn't have the possibility of bringing more panelists, and we also left when we left regions out, we left regions which also use detention as a very important tool in immigration enforcement, and we want to acknowledge that. But we are very thankful for Marta from being here from PICUM, because I think Marta can kind of give us an idea or a perspective from Europe, from the European Union. And I was wondering, Marta, if we can start by asking you to elaborate a little bit on what's happening in Europe, particularly in regards to returns, and of course, in the context on the new policy on returns. Thank you, Marta, for being here.
Thank you very much, Elena, and thank you very much for the invitation to speak today. I'm very happy to be part of this panel. I was thinking to maybe give a brief outline first of 3 main reforms, very briefly, for those who come from different regions and might not be familiar. I think we can get it to 3 main proposals which are being discussed. On the one hand, the Returns Directive, which is the main piece of EU legislation which governs returns in the EU. And the first Return Directive is from 2008, and this has been now recasted since 2018. The process is still ongoing, and I think this can also show a bit how controversial this issue is There is more, I think the Parliament is considering now more than 700 amendments to this directive. The second reform that we have also witnessed over the past years is the reform of the Frontex, the European Border and Coast Guard Agency, which starting from a small agency is now increasing in terms of powers and in terms of staff, with more than 100,000 staff which will be hired by 2027. And what is important is that Frontex will now have also powers in the field of returns, including, for instance, voluntary returns, return counseling, and even drafting return decisions that be adopted by states. And the third reform, which is particularly important, is the EU Pact on Migration and Asylum, which is still a proposal, which has been published in September 2020. And it comprises 4 legislative proposals as well as 5 recommendations, which are now being discussed by the Parliament and by the Council. And the pact has several objectives, but what is really primary in the whole pact is the idea that increasing returns is considered to be part of a migratory policy which is efficient. And I think this is the main point here that I would like to discuss and challenge, because I think this is also where the problem lies, and it is also very strictly interconnected with the resort to detention in the EU. Just to give an example, in the communication that the Commission released on the pact, the term detention return is mentioned, I think, around 100 times. So this really shows how this is a massive focus for the EU. All these reforms are based on what we can consider a binary division of the word, in which migrants who arrive in an irregular situation either apply for international protection and are granted asylum, or are considered to be undeserving. And in this way, they're considered to be automatically destined to be returned to deportation procedures. And I think what was mentioned by previous speakers, by Sumit and Pablo in particular, the importance of regular pathways and not criminalizing labor migration is particularly evident here, because in the whole pact, the references to regular migration are very few and insufficient. And they really show the idea that migrants are considered to be deserving or undeserving. And there is a complete lack of understanding of what returns mean. I think, Helena, you described it very well before when you talked about deportation and also in the concept note, and that really highlights the violent nature of these measures. And I think when we talk about returns, which conflates voluntary, although we can then discuss maybe separately what does it really mean, voluntary returns, in particular in the context in which it is applied during detention. But even these voluntary returns is conflating with forced returns, which are often very violent measures. There have been information of, for instance, Frontex applying coercive and violent measures to people in the return procedures, violating their fundamental rights. There is very little research on what happens to people after they are deported. But I can share the results later. PICUM has published some testimonies of deportees. And these stories, although there are not many, because it was quite difficult to get in touch with returnees, and we work with a researcher, Gilals, for this work. And these stories really highlight how deportations means breaking family ties, means leaving people homeless in situations of destitution, in situations in which they are deported to places where they have no ties. And all of this is completely obscured in the EU policies. The EU policies consider that everyone who does not qualify for asylum should return. Return counseling, in a recent strategy proposed by the Commission, is supposed to start from the moment that people arrive in the EU, when they're detained, even during the asylum procedures. And I'm going to be brief, but I think the main consequences of this are two. On the one hand, we can see a risk of increase of returns in violation of fundamental rights, and it is something already happening, in which people are returned in violent ways, are detained for very long periods before being returned. And on the other hand, and it is also something that PICUM is working on, the fact that because there are no pathways accessible, and this is also something that maybe we can elaborate later, are the pathways, why they're not accessible and how can we make them accessible. But because of the lack and even the closing of existing pathways proposed by the European Union, more and more people will be forced to live undocumented in the EU, which means that they will not have access to healthcare, they will often not have access to education, to rights, to justice, and they will be pushed into exploitation and forced work. Thank you.
Thank you, Marta. You've definitely given us a lot to think about. And I think that there may be some of these topics that we would like you to perhaps expand a little bit more in the second round. I realize that it's like you begin describing a situation that it's more complex. You just unpack the first layer and then we are moving on to this discussion. So in many cases, I think that we're going to do for the second round is to ask you to continue unpacking some of those topics that you were only able to kind of mention very briefly in this first round. And Wayne, now let's move to the situation in South Africa. And it, again, I think that similarly to Pablo, what I would like to ask you if in this first round, you can tell us about the strategies that are being successful in terms of detention, and then we can discuss deportation in the next round, particularly in the context of the pandemic. Thank you for being here with us today.
Thank you very much. In terms of detention specifically, I think to arrive at COVID and the pandemic and the strategies that are working now, it's important to have a holistic look at what has happened, speaking specifically for South Africa, in that we've had legislation which provides a lot of the safeguards that are meant to protect people from detention, whether it's certain classes of people who should not be detained for the purpose of deportation, like asylum seekers, refugees, children, whether it's statutory limits to detention, the need for verification and timeframes. But practically what was happening is because there was no oversight, as an example which was mentioned in Malaysia, where someone could be arrested and detained for over a month, sometimes as long as 2 years, without ever having seen a court, because if there's no oversight, then there's no need to actually implement the law. And so one of the big strategies that we used obviously was litigation to first of all, secure release for a lot of different individuals, but then to use a lot of those applications and testimonies to show that there was a systemic issue in that the law was not being followed. And using constitutional arguments, we're able to get legal reform through our constitutional court to say that there should be judicial oversight over all immigration detentions. And that happened in 2018. And what we saw was quite a significant drop in the amount of detentions and deportations, which I know we'll come to later, but as a good indicator, whereas somewhere between 30 to 40,000 people were being deported a year, that number dropped to 10,000 as soon as there was judicial oversight. And also the incidences of vulnerable people detention also significantly dropped at the detention centers. Now with COVID, what we saw was obviously the big strategy, as horrific as the pandemic was, the fact that it raised public health as a primary concern in the populace and as an advocacy tool, we were able to advocate for the release of over 20,000 low-risk inmates, and also pushed for a moratorium towards detention, which is the basis of deportation. And so detention numbers also fell significantly. And what we're able to do is also advocate to our Ministry of Justice to move away from detaining people at police stations for what we call petty crimes. And that was initially meant to include foreign nationals as well, and prevent people being detained and being moved into detention facilities, which would create a public health risk for people who are either coming into contact or moving out of detention areas. Now, all of those measures were good, and I think there was a gradual decrease in the amount of detention, particularly unlawful detentions. But the problem was, the backlash was that we then saw a lot, and I think Michael alluded to this, the fact that detention is not just administrative. We saw a shift away from administrative detention because the law didn't allow it anymore, towards immigration detainees being processed through the criminal justice system, which is not something that was prevalent a lot in the past. We also saw an increase of whilst some of these guidelines during COVID around petty criminals being released or being remanded so that they were not detained, at a point in a lot of different areas, this was not applying to foreign nationals who did not have their documents or whose documentation could not be verified, which was also very difficult because a lot of the reception officers and service providers for asylum seekers, refugees, and foreign nationals were closed. And so there was now a lot of undue long-term detention, and also immigration detainees shifting from being detained separately in remand deportation facilities to now being incarcerated with inmates, even if it was solely for deportation. What we've also seen is over the last year and a half, a lot of reaction in terms of legislative changes to legislation governing refugees and governing border control to be a lot more restrictive, to restrict people into access to the refugee and asylum system, since that is one protected group that cannot be detained and deported, and a lot more focus on immediate border repatriation before people can get access to the safeguards that exist. And so there's this constant push and pull where one strategy, whether it's advocacy, litigation, policy reform, yields some success, but then there's always an inverse reaction from the state to counter the effect of that. And that's why it's a constant battle, and I don't think there's ever an end goal in terms of whether you want to call it alternatives to detention, the fight for liberty for people who are, I suppose, encounter the state for migration purposes. It is something that you kind of constantly work on. And then the last thing I'll mention is a lot of the strategies are not just strategies that are implemented nationally, but we try and interact regionally with a lot of the reg bodies in Southern Africa. We have a Southern African Development Committee where there's a mixed migration dialogue where we're trying to reform a lot of the detention policies, a lot of the birth registration policies, which leads to statelessness, which is also a big reason for what ends up being termed immigration detention. And so, like, it's important to have a national and regional angle. And then that language is important. So in Southern Africa, the kind of terminology of alternatives to detention is something that is receptive to a lot of governments, as opposed to liberty and a lot of other things, because in most states, there's very clear laws around how you govern detention, deportation, and stuff like that. And there are a lot of security concerns that governments try and throw out. But the alternatives argument has been effective mainly because it seems to be something that governments feel there's a balance of both sides in terms of maintaining their migration regimes whilst being beneficial, cost-effective towards their goals, as opposed to just, I suppose, a liberty argument to say we should be moving just towards a human rights argument, which is obviously what we want. So the kind of politics of language also changes region to region, just to, again, harken on to what Michael was talking about, in that there's definitely not a one size fits all, but you try and use a language that's beneficial to a particular region. I'll stop there for now. Thank you.
Thank you very much, Wayne. And I think this, of course, you're adding another layer to the discussion, which I think is also very important in terms of how authorities react and how you respond to those reactions. I would like to go back to our panelists with a second round and ask you whether you have any reactions to some of the comments made before by the other panelists, or whether there were specific elements that you did not have a chance to cover on the first round that you would like to cover in the second round. And I would like to give a chance, Pablo, perhaps, if you could start this second round, talking a little bit more about returns in the context of Latin America. What you're seeing, you mentioned some topics, and I think that something that we definitely would like to understand is why we were on a positive trend, that we are now observing that there seems to be some regression and there is more deportation now. Pablo, the floor is yours.
Sí, gracias. Yo diría, especialmente en Sudamérica, porque es donde más aplica tu pregunta, que estamos en una situación muy heterogénea. Tenemos realidades donde, por lo menos en términos de detención y deportación, encontramos la no aplicación de medida alguna de privación de libertad, como decía antes, y por el otro, que por lo menos frente a la irregularidad administrativa, la respuesta casi única o mayoritaria, diría, es la regularización. Es facilitar el acceso a un permiso de residencia por diferentes motivos, regulados en la legislación de cada país. Incluso hay países que están haciendo lo que se llama abordaje territorial, es decir, presencia en las comunidades, en los barrios donde se sabe que hay mayor población migrante y que está en situación migratoria irregular, para facilitar el acceso a ese trámite de residencia. O sea, no para perseguirlos, detenerlos y deportarlos, sino justamente para regularizarlo como parte también de una política de inclusión social, ¿no? Ahí hay una discusión que me parece que es clave, pero tal vez en otro momento podríamos dar, ¿no? Yo creo que hay muchos elementos jurídicos y de política pública para definir que hay toda una serie de obligaciones de regularización, de canales de regularización permanente por parte de los estados. Pero bueno, tal vez lo podemos dejar para otro momento. Entonces, tenemos ese tipo de realidades. En esos países tal vez la discusión sobre deportación se centra más en deportación por razones penales que administrativas. Es decir, la deportación de personas que cometieron delitos, ¿sí?, no migratorios, ¿sí?, otro tipo de delitos de la legislación penal común que rige en cada país, ¿sí? Entonces, la deportación como consecuencia o posterior al cumplimiento de la pena que la justicia penal estableció, ¿no? En muchos países la discusión está focalizada en eso, y hay importantes discusiones sobre debido proceso, sobre si esa deportación separa a la familia y si el principio de unidad familiar no debería ser un criterio superior que la facultad del Estado de sancionar nuevamente a quien ya sancionó por un delito. Entonces, algunas discusiones están ahí. Pero sí es cierto que en los últimos años han habido algunos casos en algunos de los países donde han habido ciertas formas de devolución, tanto en frontera como de deportaciones posteriores al ingreso y a la permanencia en situación irregular de algunos países. Esas tendencias para mí tienen que ver sobre todo con la aparición en algunos países de la región, a nivel de agenda política y de ciertos gobiernos, de discursos que encontramos en otras regiones, ¿no? La migración como una amenaza, la migración como un problema, y la respuesta más militarizada o más de seguridad, en contra a veces de lo que dicen las mismas leyes de esos países, pero de alguna manera como estrategia también para enviar un mensaje a sus sociedades, especialmente a veces en contextos electorales, y sobre todo porque, bueno, son países que han recibido un número importante, ¿no? Piensen en Colombia, casi 2 millones de personas que llegaron en pocos años, en Perú más de 1 millón, en Ecuador algo parecido, en Chile un número un poco menor, pero no mucho menor. ¿No? Estas deportaciones no han ocurrido en todos estos países que acabo de mencionar, ni tampoco ocurren de manera sistemática. En Colombia, por ejemplo, ha habido y hay ahora un reforzamiento de los planes de regularización y de acceso a residencia más estable. Lamentablemente en Chile, Perú y Ecuador sí se ha impuesto un visado, lo cual en contextos de crisis de desplazamiento humanitario, como ha sido el contexto venezolano, lo único que ha generado es el aumento del ingreso irregular. nada más, no frenar la migración, sino el ingreso irregular, lo que vemos en otras latitudes. En lugar de solucionar eso, lamentablemente han aparecido estos discursos que la respuesta es de seguridad, la respuesta es militar, y es ahí donde aparecieron algunos casos de expulsiones como en lugar de solucionar esos problemas. Me parece que todavía es un escenario que no está claro hacia dónde va. Hay países que han retrocedido en los últimos años también en su legislación, como Argentina, pero ahora, recientemente, se ha vuelto como a la mejor senda, ¿no? Y se han derogado reformas regresivas, afortunadamente, que facilitaban deportaciones arbitrarias, y eso fue derogado. Con lo cual, hay todavía posibilidades de retomar, como de alguna manera, ese consenso centrado en migrar es un derecho, hay que regularizar, hay que evitar que las personas tengan que entrar de manera irregular, y si lo hacen, solucionar eso en lugar de perseguirlo. Pero bueno, estamos en un escenario complejo, básicamente por diferentes cambios políticos en la región, obviamente en un contexto de desplazamiento en términos cuantitativos y cualitativos inéditos en la región, lo que facilita la aparición de esas regresiones o discursos que recurren a la xenofobia para justificar prácticas, como decía, contrarias incluso a leyes progresistas que se han adoptado en esos mismos países en los últimos años.
Thank you very much, Paulo. I think that it's very challenging to do a regional overview, but we'd really appreciate to be able to understand also the complexities and the challenges in South America, which I think it's an interesting trend, and to observe whether we are able to maintain it moving forward. Sumita, I was wondering if we can ask you to continue discussing the situation in Malaysia. I want to underscore that you mentioned the criminalization of irregular migration, which I think it's important because as it was mentioned in the chat, and I think it's the two components. We have on the one hand, one approach, which is criminalizing irregular migration, and then using the punitive apparatus of the state to address irregular migration. The other one is administrative detention. So I think it is interesting to learn how, like, whether it's one approach or the other, what is happening in the country, and how we are responding to it, because definitely it is a challenge of a different complexity when we're talking about the criminalization of irregular migration. And so I was wondering whether you can talk a little bit about how you're challenging detention procedures and what is working in Malaysia with this emphasis on workers. Thank you.
Thank you, Helena. I think the problem we have in Malaysia is that we view foreign nationals as a security, under the security lens, all foreign nationals. So we don't differentiate between a migrant or a person who's undocumented. Everybody is deemed a security threat. So any policies that come out from the government is to do something to do with saving the country or putting the migrant in their place. You know, so these kind of policies don't help. And so we see detention as a problem in Malaysia because like what you mentioned, migrants are detained over a long period of time. The conditions are very poor in detention centers. But I also must emphasize to you that we do a lot of a lot of the migrants are tried in groups. Example, and we call this a conveyor belt justice. So when the migrant is detained, the judge or the prosecutor takes no effort to ask or even listen to the migrant on why he's being held, or who is responsible for him being here, or what is his story. So the mere fact that he has no passport or an expired one, or that he has overstayed, is enough to prosecute the migrant. So I find this very troubling, because even a person on trial for a crime has his day in court, but then we don't view that a migrant needs to have his day in court. So, and we also have this problem in Malaysia where we do this mass deportations. And we have these arrangements between countries on deporting groups of people. So I feel that this shouldn't happen, because each migrant has not gone through the due process. So there are definitely migrants who shouldn't be deported but are being deported, you know. And so and then we also have judges, and so these judges and prosecutors are not being sensitized on the difficulties that migrants face in migration, going through the regular channel, or why they choose the irregular channel, or how difficult is it to remain documented or become documented in the country. So for Malaysia, we don't have a difference. We treat everyone as an undocumented person. So our immigration laws here are extremely strict and strong, and we can't challenge sometimes the directives that, or the orders that are given by the Director General of the Immigration. Like what you mentioned, the migrants sometimes can be deported even without a court order. So this is why I come back to the first point I made, that we need to go back to the courts, or we need to challenge the immigration procedures that they are using against migrant workers. Let me stop here, Helena. Thank you.
Thank you, Sumita. I think it's very important to appreciate the differences, and we go back to Michael's initial comments in terms of also being able to, like, there's one approach, one solution fits all approach is not going to work, and this is an ongoing discussion in the chat, which I think it's also very provocative, and some of you have made comments in that regard. What works and what doesn't necessarily work, and also how you are trying to respond to the reactions from the authorities. And I think in that regard, when you were very provocative in the end, kind of saying it's kind of the balloon approach, if you exert a lot of pressure on one side, then it goes all the way forward. And so you may not necessarily, like the alternatives to detention approach, but if you find that language creates an opening, then it's a solution, or an approach that you take. But I was wondering, Wayne, if you can talk to us a little bit about what's happening with deportations in the context of South Africa as well. How are you challenging deportations? What strategies are working? I find particularly compelling, and I want to go back to this idea of the concept of family unity and understanding the impact that a forced return has. And I want to underscore that we decided to use the term deportations rather than returns because, and Marta made this comment, and I hope somehow that Marta, you can also address it somehow. With this fiction of returns, I think it's an euphemism. We're trying to sugarcoat and to deny many of the impact of returns. And I also want to remind everyone that Marta shared on the chat the document she said with the testimonies of individuals who were returned. We have done the same, I should say, in the context of Alianza Americas, with voices of individuals returned from Mexico and from Central America. And those voices are very important to understand the pain involved in return. The human rights violations entailed in a return, which I think is something that perhaps we don't discuss enough. So Wayne, what can you tell us about South Africa in terms of deportations?
Yes, thank you. So regarding deportations, I think I'll again speak more broadly to it and what's happened during the pandemic. So generally speaking, we've seen a steady decline in deportation numbers over the last 3 years, linked to a lot of different things, including added scrutiny to deportation centers, the litigation, the policy development through the Constitutional Court, dropping all the way down to about 10K a year before the pandemic. 10,000, sorry, I'm using abbreviated language, which might not be standard globally. And with the lockdown happening, what happened in South Africa was when the pandemic happened and reached our shores, there was a lockdown which was implemented in March last year. And in the first few months, we advocated for a moratorium, pause on all deportations. And whilst there wasn't any official policy, that at least was implemented initially. And at least the Department for Home Affairs, the Repatriation Center, were observing this policy. However, they were not detaining people who were being detained for the purpose of deportation, even though they knew that they were not deporting people, which meant that they'll just catch and hold people for the statutory limit, and in some cases release them. In some cases, there'll be a release and catch policy. So the official numbers from the states that they've given Parliament is that since the pandemic, which is over a year, there have been approximately 1,300 deportations, which is obviously a fraction of the amount of deportations that ordinarily take place. Our deportations are a lot better now in that there's a lot more verification that happens, which prevents children being deported alone, asylum seekers, refugees, which prevents any refoulement happening in theory. Whereas in the past, before, there was a lot more scrutiny in the way in which our Department for Home Affairs carried out deportations. Asylum seekers, recognized refugees with permits, children, vulnerable, all sorts of vulnerable groups were being returned to places where they were at a high risk of, and in some cases, some of our clients that we heard about, where they then face that persecution, particularly in countries like where people were being deported to the DRC in about 3-4 years ago. All deportees would first be loaded off and taken by the state for verification to see if there were enemies of the state of some sort, and had a prolonged detention after that. So deportations were it was quite important to ensure that there was proper verification, there were no reformers that were taking place. And for the most part, at least the systems in Home Affairs have changed. But there are two systems that take place. There's a system that takes place inland, where we have your repatriation centers, and then there's the systems that take place at the border, where no real kind of policy or law is followed. And there's been a massive push towards those immediate returns. And those numbers as well, according to some of the information that they've given to the parliamentary committee, are quite startling, because they indicate upwards of 13,000 direct deportations. So people who are immediately returned at the border and don't really enter and don't really integrate with the courts, with repatriation centers, and detained. So, and that's quite a massive figure. And that 13,000 that was reported is simply from the beginning of this year to 20 January. So that's in about a 1.5 month period, which is kind of larger than the normal deportations that would take place inland in a whole year pre-pandemic. So that's a bit of the overview of what's happening with deportations. And it's very difficult to kind of interact and counter and stop that policy, because it happens so quickly and almost, in a sense, clandestinely, because that now also involves a new border management system, which involves the army, and it's called the security cluster, where a lot of information, we get very little information coming out of that, except for when they report to Parliament. Thank you.
Thank you, Wayne. I think it's important also to underscore the similarities that we're hearing from one region to another. Pablo mentioned before this element of the securitization of migration, and I think that it's important to observe that this is becoming a common element, which is key. Marta, you also mentioned in detail Frontex, how it has become this larger force day after day. And when you were talking about strategies that worked, it reminded me of a very important effort in the context of the US, which has been also to try to push towards defunding the agency responsible for detention and deportation, as kind of an effort to simply shrink the size and the powers of that agency in hopes of diminishing the number of people who are being detained and deported. So I think it would be very important to hear what you can tell us about what's the situation in Europe in that regard. And why is this focus on increasing returns? And I want to point out also that there are some comments on the chat, particularly in relation to the UK, which of course is not now part of the UE, but it's interesting to observe that that exchange policy, if you allow me to deport your nationals, you will be rewarded with working visas, this very sad exchange. So Marta, what can you tell us about this focus on the EU?
Thank you very much, Elena. Maybe just to pick up on the very last point that you mentioned, I think we see also at the EU level the same trend of really relying on externalization of migration control. And just to name some examples, we heard recently of the EU funding the use of databases in African states in order to facilitate deportation, while claiming that it is to protect fundamental rights of people. There is also a push already for a couple of years to link also visa policies with returns. And just last February, the Commission finalized the first review of states to see which countries collaborate with forced returns and to see what the consequences will be in terms of visa policies. I think it's also very interesting what you mentioned in terms of defunding this massive border security apparatus that we can see in different regions, and that I think it's really important. And I think also the role of private companies is something that is important to mention here. At the EU level, we have seen that Frontex, rather than being defunded, is increasing its budget massively. As I mentioned before, 10,000 staff members to be hired by 2027. In the past few years, Frontex was reported in total 50,000 people collaborated with the deportation, and the idea that the same number will be deported on an yearly basis from 2024. So we really see a massive increase. And I think this is particularly problematic because of the lack of accountability. And to mention the role of private companies, there have been also some releases, some leaks recently that show that Frontex has been in contact with private industry, which is also involved in border controls, and that apparently this relationship had been hidden to the European Parliament. And I think it really shows the power of these relationships and how they also influence them border controls. To go back to your question, which is why is the EU focusing so much on increasing returns? I think we can see it as a trend which has been increasing over the past years. I think since the action plan that was on returns, which was published some years ago, we really see what we can call an obsession on the numbers of return, on the return rates, which is always considered, at least by the European Commission and by certain institutions, as very much numerical factors. They just compare the numbers of asylum applications which are successful on first instance, and then they compare the number of returns per year, and they say we don't have sufficient returns, we have to increase them. And I think this really obscures a lot of factors. First of all, it obscures the fact that there is a parallel push to have more efficient and shorter asylum procedures, which means that many asylum procedures will not be successful in the first case because they will not be adequately reviewed, and the number of different decisions in second instance is quite high. So I think this is already a factor. The other factor is that the reality is much more complex. I think as the participants will know better than me, there are a lot of different circumstances for which people can migrate, and this trying to bring everything back to black and white, it's just not possible. And we have been challenging a lot with regard to the new PAC proposals, a number of specific ideas, for instance, linking the rejection of an asylum application with the issuance of a return decision, because if the two are issued together, if one is a rejected asylum and issued a return order at the same time, there is just no moment in which other pathways can be considered. So even if those pathways exist, and in some EU countries those pathways would exist, at least half of the EU member states, for instance, have pathways for medical reasons, but they're just not considered, and migrants do not receive at any time really the legal counseling and the support that would be very important to access this. And picking up one of the points which was mentioned also in the chat during the discussions before, I think by William, is it useful to talk about alternatives to return? And I think it is useful. I think also going back and taking note of Michael's very important comments in the beginning that there is no one solution fits all. I think it's probably the same also when we talk about alternatives to return. I imagine also listening to the situation in Latin America and other countries in which regularization might not be there, may already be there. It might not be helpful to actually frame pathways to regularization as alternatives to return. But I think in the EU context, in which there is really much the idea that return is the only option, it is important to challenge these and to say, are there other opportunities for regularization, for regular pathways, for, in certain cases, voluntary return, but this has to be really voluntary and not what the EU is pushing for. So I think a collective reflection also on what alternatives to return can be and how we can access them, both on a procedural level, namely how can we help people to access them when they exist, and also from a substantive law level. So how can we increase the number of options for regularization in the EU is something which is at the moment very much missing in the EU political discussions, but very much needed at the same time.
Marta, thank you very much. And I think that it is very, very important to make the link with the topic of pathways for regularization. In the last webinar, which was precisely on regularization, we did discuss how we can make the links between the topics that we are discussing each week, because they are very much intertwined, and it's important that we think of them broadly. Michael, I want to confess that I felt really bad that you kind of stopped in the middle of your your presentation, because you were trying to be very respectful of the time frame. So I would like to ask you whether you can continue where you left off in the initial presentation, or whether you would like to go back to, you said this is not the time to talk about alternatives to detention, but where do you think, and from listening from the voices on the ground in different parts of the world, where do we think that there are possibilities of moving forward?
Okay, I have to confess, I didn't have a larger picture to present in my previous 3 minutes. I was hoping actually everyone was going to present that as I listened, and one thing that is clearly confirmed from listening to everyone is the challenge of trying to see this issue from a global perspective. I mean, it's really, really quite complicated. And it's hard to draw lessons that would seem to apply to everyone. But one thing I will offer as a reflection, and also I've been getting some chats, some direct chats, and some people asking questions, and I'm trying to follow that as well. I don't know how I can sum up or respond to all the questions that I've gotten, but a couple things. First, one thing that has been a recurring theme is this notion of the one size fits all approach is never going to work for this issue. But let's be clear, and I think this is an opportunity to go back to clarify a little bit by what we mean by ATDs a little, because I think it's important. I think it got lost a little bit. When we look at what's coming out of the Network on Migration, they really talk about ATDs as this not one size fits all idea, and I think in part that's framed because of the same considerations we're looking at here now. But I think it's also framed that way because it's also a way to salvage an idea in contexts where it may not be appropriate. So when Wayne talks about ATDs, for instance, I know what he's telling me. I know he's talking about a way in which you're trying to find a non-custodial measure during a detention procedure and decision-making procedure. I know that that's what he's talking about. But if I were to follow the literature coming out of the Network for Migration right now, I wouldn't know what exactly they're talking about, precisely because they framed it so broadly as whatever works to keep states from detaining more people. And I think it's important that we focus on that for a second, because that's where I think we have a concern. And I think it's really important to be precise. There is that formulation, and that's the formulation that I see as concerning. And then there's the formulation of this kind of regulatory legal framework in which ATDs play a role. One of the questions I got on the chat was from somebody in a country that's a so-called transit state in Europe. And they were asking, so if you're saying that ATDs don't work in transit states, should we not focus on that anymore? And I would quickly want to correct any miscommunication in that respect, because really, when you look at the transit state of, say, Poland and the transit situation of Mexico, you're talking about very different phenomena, right? And so it's not just a matter of understanding where a country is in the migration phenomena to know what may or may not work, but also what has history told us and how do the different migration bureaucracies act in those contexts. But I want to come back to Wayne for a minute, because what Wayne seems to have presented us is this interesting kind of microcosm of, I think, something we're seeing all over the place, which is that successful efforts to counter an abusive measure, as we seem to have been the case in South Africa, created another abusive measure, which was more criminalization, more hard criminalization, more prosecution of migrants. I think that's what Wayne was saying has happened. And that for me is an important corrective, because I've often argued that, just speculating, that maybe what we should be doing is focusing our attention on this administrative administrative immigration detention, and really emphasize the fact that what we're talking about there is locking people up and not charging them with the crime. And that the reason why this is so useful to states is precisely because they don't have the kinds of procedural guarantees that you were talking about at the opening, Elena. And so that has been an evolution, but it becomes a much more expensive endeavor to do that. You know, I mean, if Italy, for instance, wanted to start prosecuting everybody for all the different undocumented workers, they would have a massive detention infrastructure to deal with that. And so it would become prohibitive. But on the other hand, there may be cases where countries find it actually more useful to go that criminal route, and we would want to be cautious to avoid that. So this kind of then starts talking about this, the unintended consequences of some of our actions. And then the thing that Wayne then followed up with regarding deportations was quite interesting, is that you start seeing deportations just at the border, where you can't monitor it so much. And that is then another solution that states implement to try to avoid some of their responsibilities. So it seems you kind of have this motion or this movement in South Africa that I think you can see reflected all over the place. You can see it with Marta talking about Frontex. You can see it when Pablo talks about what's happening with a lot of the securitization that's going on in Latin America, especially with the large numbers of people that have left Venezuela. And I think this is probably a real global phenomena that we're going to see if we're successful in restricting detention administratively, or even criminal detention related to immigration. We may start seeing, and we are seeing, in fact, an effort to keep people from even getting in the border, and also hiding from us where the movement of eliminating people from the public sphere is happening, which is at the border. And very importantly, it's not only happening at the border, but it's happening in a lot of these countries that don't have regulatory frameworks at all. And so I know that I'm not wrapping everything up, but I'm just kind of trying to reflect on some of the challenges that I see coming out of this conversation. And ultimately coming back to something William had written in the chat, which was, how can we take into account all these regional differences and yet keep in mind that there are some ground, there's some baseline ideas and norms that we need to always keep in mind. And I think that's an important point to take, because that's really going to be the agenda. If we're going to think about a global agenda, it's going to be that we agree on the norms of how people should be treated. And that will be our guide, you know. And I think the fear that I have with the way in which the Network on Migration is set up, and also the compact with this focus on ATDs as anything that can keep states from detaining people, is creating a norm that doesn't make necessarily a lot of sense. It kind of avoids the hard truth, which is that if you tell states that that there's something called ATDs, and that can be anything they want it to be, including giving somebody access to an asylum procedure, then you're creating something that could be set up for failure. And so I think I'll just leave you with this idea that ultimately, even though it's not politically savvy to go to states and say you must respect the right to liberty, ultimately that is the norm that we're going to work towards, right? And the different tools that we set up will be one that are really focused on that particular norm. Anyhow, thank you very much.
Thank you, Michael. I think that you really wrapped it up, even if it was not your intention, because I think that we've really gone 360 degrees back in this discussion. If you look at the beginning of the chat, some of the first interventions were, why don't we go back basically, you know, to universal human rights standards? Why did we depart from them, and where is this conversation going? And I think that there have been a number of important voices in the chat, and I would like to give some of them the chance to share their questions live, and I want to ask them to please be very short and precise, so that we can ask a round of questions and give the panelists the chance to give us short answers. One of the persons that I would like to invite to the floor, and I'm going to name them because I know that they have to be unmuted, is Ray Kozlowski, who's from the United States. And I think that considering the massive use of detention and deportation on the part of the US, we were very sorry that the speaker that we wanted to bring from the US was not able to be here in this conversation, but it will be in one moving forward. I also would like Rula Hamati, who also made, I think, a very interesting comment on the chat, to please come to the floor. I would also like to invite John Bingham, who I saw raised his hand, and finally William Goy. So why don't we go with those 4 interventions? I want to ask you to make sure to present questions or comments very briefly, so that we can give the panelists a chance to respond to them. Ray? I can see you're still muted. Ray Kozlowski,
okay.
There.
Hi, there we are. Thank you very much. My question works off of what Michael had noted, that migrants detained in Zambia might be subject to 1 year of hard labor if they don't pay a hefty fine. I was wondering how many other countries compel migrant detainees to work. Because here in the United States, we have the voluntary work program, which puts detainees to work for $1 a day. There have been various lawsuits. One of the most recent ones has been here in New York, which has been supported by the Worker Justice Center. You can see the press release there. And one of the things they point out is that a lot of the migrants who are working, these detainees who are working as kitchen staff and janitorial staff, are putting themselves at increased risk of getting COVID because they're working in the infirmaries, for example. And I was just wondering, a question for Michael and Marta, to what extent do we see detainees in the US and elsewhere replacing detention center workers who might have gotten sick with COVID? And are these detention administrators, are they using detainee labor to limit the spread of COVID into the communities surrounding the centers? Thanks.
Thank you, Ray, for that question. Now I would like to give the floor to Rula Hamati.
Hi, Elena. Thanks a lot. And it's been a really great discussion to listen to. So I really don't know where to start, but I guess just maybe something that, Michael mentioned about, there is no, what do you mean by alternatives to detention? I think this is a very important question. And the current framing of kind of anything goes is really problematic, because what we see is in different contexts, some things are labeled as alternatives to detention, right? But when we scrutinize them, we find that people are still deprived of their liberty. So I think the question is to be asked here is, what is the standard? What is the minimum standard that we are all talking about when we say alternatives to detention? And I mean, in many contexts, we do have organizations, even sometimes starting from a goodwill or from a good space, kind of being dragged into these measures where really at the end of the day, what is happening is that people are still deprived of their liberties. It's being implemented. Sometimes it's also becomes so unclear because the state is not doing it, but then somebody else is doing it. And so it becomes this big gray area where we don't know what's happening, and it's not really kind of working towards ending detention in no way. It's really kind of keeping the status quo as it is. We've seen this not only with organizations, but we also see this, and I think this is another question, the whole question of shelters, right? And who operates shelters and how are shelters operated? Sometimes it's embassy shelters, sometimes it's NGO operated shelters. And how are these shelters also functioning? I think this is also kind of merits a question. And I mean, I think Sumita really kind of shed light on how this is all happening in the context of labor migration, how people are criminalized, and it's really kind of time to challenge the whole framework as only kind of looking at the small side of things, which is looking at alternatives. How do you take the bigger framework into question? But yeah, just my thoughts.
Thank you, Rula. John Bingham.
Yeah, thanks very much. Thanks very much, Elena, and thanks to all the organizers. What a terrific panel on two of the hardest questions I've ever seen in immigration. Working on the ground with as a service provider, as a partner with immigrants and refugees, working in advocacy nationally at city levels and internationally, return and or deportation. I was very glad, Marta and others and Elena, for the precision on the term, the accuracy on the term, that we're really talking about deportation and not a euphemism for all sorts of horror, really. But as well, alternatives to detention. And so to follow William and Rula a bit, and especially Marta, Wayne, and very much Michael a few minutes ago, alternatives to detention are precisely that. And I think we've got to look, as Rula says also, at what exactly the alternatives look like. What are the norms? What are the human rights that have to ground and frame and structure any alternatives? But I think as united civil society, or another word for it is powerful civil society, at every level, I think we know how to walk and chew gum at the same time. We can fight for abolishment, full reform of these systems, and while we're doing that, try and remedy at an individual level the horrors and the traumas and re-traumas of detention as it exists. I think we have to do both. They're not opposites. We have to be careful in civil society not to self-destruct our broad movement and our multiple fronts on this. And I'll close just by saying my own work in alternatives to detention, I didn't know much about detention or any alternative building until in the community where I was working, we had 90 Peruvian undocumented migrants trafficked and caught up in the FBI in the US and all sorts of law enforcement. And they were threatened with custody and worse, and custody would lead to deportation. And they said to us, please get us out of here. And we said, we're not sure we can achieve the result that you should have as a human right, the result that you deserve, the result that we would want to be part of helping make happen. And they said, just can you please get us out of here? Because the conditions today are so awful the abuse we suffer at the workplace, the physical and sexual abuse we're suffering at the hands of the traffickers, and maybe can fear in detention, get us out of here. And so we walked and chewed gum at the same time. We worked on an alternative, on home-based, shelter, and we negotiated hard with the government towards the liberty that they eventually got. Now that was a happy story. It won't happen in every case, but we can do both things. Thanks.
Thank you, John. William.
Thanks, Helena. And every time I listen to this debate on detention and returns, I think it is very important for us to go back to look at what is at the heart of this. And I think we'll have to do some real serious thinking, even as we look at this, now as the world kind of recovers from this pandemic, and there will be movement, and there is going to be a lot of movement as economies try to recover and things like that. And we can see that already happening. I think the questions that have been put on the panel today of how do you look for situations or tailor responses, and the example that John gave is a tailored response, or that Martha gave are tailored responses, or Mike is talking about tailored responses. I think that there is today, for the first time, I see a global alternative to the alternatives discourse, and that is this tailoring response to context that is rights-based. I think if we can, I remember many years saying, what is the alternative to globalization? There is no alternative to globalization, but there are several alternatives that are context-based kind of thing. And I think this is what, because human rights progresses also in different contexts at different paces kind of thing. So without reducing it to relativism, we've got to be able to see how we can work with context, tailored responses, with keeping the base, the common base, that is a human rights base. I think this is something we might want to explore more in building the global movement on this.
Thank you, William, for that. We have two persons who raised their hands, and these are going to be the last two interventions, and I will ask you to be very brief so that we can give a chance to the panelists to respond. The first of those is Malani Kandarchigne. Please excuse me for my terrible pronunciation of your last name. And the second is Kyle Hitman, who's from the UN Migration Group of Children and Youth. So I would like to start with Malani.
Hello, hi. I am from Lebanon, and I like to see in Malaysia what she's saying also. To like Lebanon, we have the problem in our employer. They have didn't take care of us and no make time to our papers, and we are the person who was to go into jail, and they are free, and they has to do our papers time, and they has to take care of us, our security. They don't do it, and this is the problem more we are facing for a problem almostly. And this time with Corona and the bomb explorer, we have lost many migrant workers in job in Lebanon, and the company is closed and everything lost, and the migrant workers has to leave country without money, without salary, without job, and what they are don't know what they are going to. Nobody look at after them, nobody take care of us, and many of them lost everything this country. This is why we need security for us. We are going outside the country to work, and guarantee who was take caring for us also. Thank you so much.
Thank you, Malani. Kyle, finally, what is your question?
Give me 1 second. So I work with people detained in immigration and customs enforcement custody or ICE custody along the US-Mexico border. And right now, most of the migrants in detention are Portuguese-speaking Brazilian nationals. And according to our interviews with these individuals and their written applications for asylum, they are seeking protection due to a multitude of reasons. And usually when a lot of people arrive from one country, they will share similar claims or similar problems or similar stories, but this has not been the case for persons coming from Brazil. And moreover, Portuguese, though it is one of the most spoken languages in the world, is relatively uncommon in the United States. And as such, civil society and legal aid, and even like the US government apparatus and ICE themselves lack the capacity to properly communicate with detained migrants from Brazil. And well, the ideal solution here, I think, would be to release every migrant in custody and fully disband and abolish ICE. It's unlikely that this will happen, but instead, in certain cases, the USA will grant temporary protected status or TPS to persons arriving from countries deemed to be manifestly unsafe. And like here in San Diego, if Brazilians were to receive TPS and leave ICE custody, it would cut the detained population in half. So my question is, do you see TPS or similar statuses as a viable way to curb migrant imprisonment and deportation in receiving states and regions that are more hostile to immigration, like the USA has been? And why or why not?
Thank you, Kyle. TPS is a temporary protective status, which is a specific measure granted on a country. And I think this connects us back to the discussion on regularization pathways. Of course, a path has to reach its ultimate goal, which is permanent residence, which is not what happens with some of these temporary status. But I would like to give the chance to our panelists for a response to these multiple questions and comments. Please choose those that you felt spoke more directly to you. And I would like to start with Sumita.
Hi, okay. In terms of race question, in Malaysia, we don't use detained migrants to work in the detention centers, but we do that in prisons. So inmates are made to work in the kitchen and things like that. So we don't have the, so if there are staffs who have fallen ill in the detention centers, they are not replaced by the inmates, but they are replaced by other staff, Malaysians. In terms of Rula as well as John, I think I really have a problem with this alternative to detention, because we did have many discussions with the government here on alternatives to detention, but it's always about another form of detention. And I think that is the problem. And also to Rula's question about shelters, are they another form of detention? What kind of principles they operate on? I think we need to look at the context, because there are shelters that need to be closed because of the vulnerability of the migrant or the vulnerability of the person that is going to be in the shelter. Example, we do house migrants in shelters which are closed, especially women migrant who are facing domestic violence, because we do not want her spouse to know where she is, you know. But then the choice is given to the migrant to decide whether she wants to stay in a closed shelter. And we do, as a civil society organization, we do have many options where we shelter migrants. We shelter migrants for pending the resolution of their case. So what we do is we ask the migrants, we actually sit with the migrant and do a risk analysis to see whether the migrant is able to be in an environment where he will be safe on his own, or does he need some form of security. But ultimately, I leave it to the migrant to decide whether he wants to stay in a closed shelter or in a place where he could move around. Because I think it's important for the migrant to have that kind of say in his own movement. Yeah, so I think these are things that we have been doing here in Malaysia. Thank you.
Thank you, Sumita. I would now like to give the chance to Wayne to answer some of the questions and comments.
Thank you. So I don't think there was any specific question that relates directly to me, but I maybe just wanted to kind of carry on the discussion around the use of shelters and speak to that. And also there's some points that Michael also spoke to. But on shelters, this is another story that we had like during the pandemic. When it initially began, there was an effort by the state and a lot of provincials and municipalities to create shelters to house and deal with homeless people when we still had a hard lockdown and they did not want a lot of people in public. And there were two particularly problematic shelters, and both predominantly had migrant homeless people, one in a border city, Messina, and another one in Cape Town. And both were eventually shut down after a lot of controversy and a lot of scrutiny from human rights monitors. But what was effectively happening was those shelters were, for all intents and purposes, detention facilities where a lot of broader rights violations were happening, where there's obviously deprivation of liberty in that people would be rounded up and not be able to move from there. But then they'll then also be screened by immigration officials and then also screened by police officials. Their fingerprints and data and biometrics will be taken and ran through criminal databases. A lot of stuff that in the normal course of things is a clear violation of privacy and would not be, would be unlawful without a warrant. And obviously all that information is captured now in police and state databases for years. And likely they're shut down before the immigration inspectorate then kind of separated individuals and started some deportation proceedings. What did happen was a lot of individuals were then given notices to depart, to self-deport for individuals who were in those shelters before the kind of scrutiny on them shut those places down. I also want to kind of come back to the discussion around alternatives and I suppose the language around it and the problematic nature. And I think maybe because obviously we in a jurisdiction that for 2 decades really struggled to find a foothold with governments in the region to kind of entertain reforms and have integrated migration policies which had some aspects, rights-based aspects. And it was only after introducing some of these models and specifically the language, this is at a regional setting, that we got some traction around that. But I agree with, I suppose maybe I'm also not in tune with the broader global discussions around detention alternatives and what that might mean broadly. But anything that does not secure liberty for someone and that does allows someone to integrate in some way into society would not be an alternative to detention, because someone will still have be detained and have their liberty kind of taken away from them. But along with alternatives to detention, I always say alternatives to detention and deportation, particularly refoulement, because even if you're not, you don't have some sort of hard and strict detention policies, if you're still sending people back, returning people back to situations that will lead to their prejudice, it's still something that is problematic and something that should be challenged along with the deprivation of liberty. Because in a lot of cases, particularly in our region, where a lot of the detainees are sent back as either a lot of political asylum seekers being sent back to the Zimbabwean regime, to the Somali conflict, to the DRC conflict, or the situation in Burundi. It's really that deportation refoulement that is the key issue that we're trying to prevent, and the key where the greatest rights violations will take place. And so a lot of kind of deportation reform is a massive focus of our work, over and above just the detention reform, where there are already a lot of different safeguards. And something that we've seen in our new refugee amendments policy are the introduction of a lot of these securitized provisions which allow for the deportation of even recognized refugees. In other words, you're already acknowledging that this is someone who will face persecution, but you're now making provisions to deport them, whether it's for vague national security reasons or for exercising their political opinions in the country, and all sorts of tenuous things, or for having arrived late for a renewal, which kind of defeats the whole objective of kind of refugee and asylum protection, because ultimately it's a lot of asylum protection is based around stopping non-refoulement and ensuring that people don't go back there. So the kind of fight against, luckily a lot of these reforms have not been implemented because of the pandemic and the shutdown of refugee services almost entirely. But that is kind of the elephant in the room that awaits us once this whole pandemic ends. Might have taken too much time, sorry for that. Thank you.
No, thank you, Wayne. I really appreciate that you're bringing the discussion on refugees and non-refoulement, because I think that it does overlap. And it's also very important to understand, you know, the multiple challenges and how, when as an advocate, you have to choose, you know, and focus on the most egregious danger. And if it's ensuring that someone is not returned to a situation that they flee from danger, that's also very important. And it also underscores that this idea, which was mentioned before, you know, about trying to separate very nicely and clearly migrants from refugees, does not actually operate on the ground. That's not the reality, and that's the challenge that we all work with every day. So I do appreciate that. Marta, I would like to give you now the chance to respond to the questions and comments.
Thank you very much, Ellen, and thanks also for all these very interesting questions. I noted down a few that I would like to reply to. Maybe starting from Ray, I have to say this is not something that we have mapped in the EU, so I cannot really give a comprehensive answer. What I know is that in the UK, there are also cases of work in the detention centers, and in the Brook House, which is one of the detention centers, there were apparently 116 paid work roles recently, and the wages are also very low, I think around £1 per hour. But this is not something that we have been mapping. So maybe for further information, maybe Michael or other speakers will be able to give more information. Maybe something related to that is that in other countries, like in the Czech Republic, for instance, detainees are also supposed to pay for their accommodation and the food. And it is also very problematic, because when they are not able to pay for it, they are released and with a debt note. Moving to the other round of questions, which was on ATDs, and I noted down a question from Rule and John in particular on what are exactly ATDs. I would maybe first like to echo what Wayne has said, that if we talk about alternatives, we have to also link it with returns. And from our perspective, alternatives do work if they also challenge return. And the model that we have been promoting is the model of case management. PICUM, together with International Detention Coalition, has also been part of the European ATD network, which is a network of NGOs which have been using case management to work towards case resolution. And now I think we could maybe still talk about it for hours. I'm going to keep this short, but I think in some cases when we talk about case management, it has been helpful to talk about it as ATD, even though it has been implemented by NGOs and not by government, and even though it has been implemented in cases in which people were not directly detained before. But in the context of the network, alternatives has always been interpreted as a provision of case management, which is not a restrictive measure. It is not something which deprives people on the liberty, but on the opposite, it's a measure that helps to support people to work toward the resolution of their case. And this includes regularization when possible, as well as other options for resolving their cases, as Elena has said, working towards a permanent outcome. And I think this is really key. This is also something that we have been pushing at the EU level to try to have a definition of what case management is. And I think this is a very important concept for us because it can be an alternative, but it can also be a more general model that we promote as a model to support migrants to work towards the procedures. And that can also help us to kind of imagine how we want to see a world in which detention does not exist. And just to really be, for a moment, also because we're at the end of the webinar, just maybe be idealistic and think about what do we actually want? If we think that we don't want detention, how would we imagine people arriving, in PICUM case, people arriving in the EU in a situation of irregularity, and how can they be supported to work towards a permanent outcome which is satisfactory to them and which respects their fundamental rights? And for that, I think that having one person which can be called case manager in different contexts can be called different ways. And of course, the way that this is provided can also, of course, change depending on the context. But having one person which supports them, which provides holistic support, which helps people to also meet their basic needs, so to access education, healthcare, legal services. But that very importantly is not a decision maker. I think the very key aspect here is that the person who supports them will not be the person who will finally take the decision on their case, but it's someone who's independent. And I think this is why the role of NGOs is also very important, because they have a long experience in working with migrants, in providing support and in establishing a relationship of trust. And this model, which is the model that has been implemented by the European ITD network, has been very successful in supporting migrants to work towards a case. And what is very important for the work of the network is that we're not talking about alternatives as something that aims to increase the number of returns, because we want to challenge the idea that detention has to increase return and then alternatives also have to increase return. But we want to say alternatives work, case management works, because it helps people to meaningfully engage in their procedures, to be informed, to have access to rights, to feel that they're being supported. And then ultimately it helps them to find case resolution in different ways. And we really push towards more options for regularization to be included in this case resolution. And there has been also, I can put the link later, there have been some report from external evaluator of how case management has worked. In these 7 pilot projects, the report focuses on 3, which has been running from 2017, but at the moment there are 7 organizations in 7 different countries which are implementing pilot projects in which they provide case management. And the reports have been very successful, with above 90% of people who say that they feel that they have been supported, and around 25% of people, I think, who have achieved case resolution. And I will put all the links afterwards. So this is to reply to the question, how do alternatives look? For us, alternatives which are successful have to be community-based, and people have to receive the support they need, the information they need, the legal assistance they need. And at the same time, they have to be supported in working different options. Return, I think I said it already many times, but return can just not be the only option. Otherwise, no alternative will work. And I think this maybe links to the very last point from Kyle, which is what are the role of regular pathways? I cannot comment specifically on the TPS. PICUM does not work on asylum, but what I can comment on is I think that these permits, a broad array of permits, is very important to be able to address different situations, and encouraging people to access them, allowing to access them, having a set moment in the procedures in which people can assess different permits is really important to prevent detention as well. And this is maybe to close a bit the link between detention and return.
Thank you, Marta. Michael, I would like to give you the chance now to respond to some of the comments and questions made by the persons who intervene, or even by the other panelists.
Sorry about that. Well, that's a lot to respond to, but I'll briefly just. I think the other panelists have addressed some of the questions. Ray, I actually don't have many cases to point you to with respect to whether or not detainees are replacing workers in detention centers. I haven't actually come across anything like that. Regarding one of the things that I think Kyle said that was really quite interesting, and I think it speaks to the issue of how we're framing alternatives to detention and broader advocacy on this issue. TPS is a tool that exists in a particular context. And I think that speaks to what we're talking about here. That, but you reminded me that there's an element, when I mentioned a bunch of leading questions that we would want to ask about how we would determine an advocacy strategy on a case-by-case basis. One thing I did not mention was asking people when they arrive why they've come and what are their aspirations. I think that that is really a critical issue. And in the case of the Brazilians that are being confined in the border, finding out why they're there, what led them to be there, is obviously critical to be able to have an appropriate response to that. I think it's important, though, to distinguish between ATDs and TPS, right? I mean, temporary protected status and other forms of protection are things that are available in many jurisdictions in the world, and they're there because of the obligations that states have. They're not about whether or not you should be detaining somebody or not. They're about being able to offer people things that they have a right to. And in the case of the Brazilians, it sounds like, yes, that's a very important measure to be able to provide them based on the reasons for them arriving at the border. And I guess I'll just wrap up a little bit. I think what Marta is mentioning about the pilot projects and the success of ATDs, that's a really loaded question, right? The success of ATDs. And I think she rightly points out that the success should be thinking about how people can regularize their status and stick around. But as we all know, ATDs properly understood as ATDs in the way that I'm talking about them, the kind of the legal ATDs or something regulated by law as part of a detention procedure. It's not about regularizing their status. And that's a very uncomfortable reality, right? It is about determining whether or not that detention measure is necessary and proportionate in that case. And to speak to what Rula was asking, so what are the standards? Well, first of all, if you were asking me what the standards would be, that would be the first. That is the role of ATDs. So when you hear somebody say, well, we're doing human rights-based ATDs, well, for me, that's a redundant statement because ATDs are about a fundamental human right, not to be arbitrarily detained. That is built into the concept. And I think it's really important that we recognize that because that is crucial, and we don't want to lose that. It's what else is happening that I'm concerned about. And I think that when we look at some of the pilots that Marta refers to, we may not be thinking about ATDs this way any longer because I think as she'll recognize that a lot of these pilots are built on a kind of a voluntary basis of people who aren't in detention procedures at all. And so you're trying to design things that may be convincing to states eventually, right? In most of these cases, but you're talking about kind of finding some people who could be subject to detention but aren't, and finding a case management solution for them. So that's actually outside the context of ATDs, is I'm trying to say is a very valuable form of ATD, but it's something different, I think. Maybe I'm wrong about that, but it seems to me that that's where we're at here, right? That with ATDs, we should be thinking about something that is a measure that is aimed at making sure that someone's not being arbitrarily detained. And then on top of that, if we're going to talk about what standards have to be, they do, as Wayne pointed out, they do have to be things that give someone liberty. They should not be, as Rula says, other forms of detention, or things that we see in Malaysia, as Sumita is mentioning. There are so many of things like that. And in the case of the United States, as I'm sure Kyle will know, is that one of the big things used there is these ankle bracelets. And so we see that has become the standards. This is a non-custodial measure, but that is one that really serves as a prevention to enable someone to really start to integrate into society around them, which is why it shouldn't be considered an ATD, properly speaking. It should be considered a form of an extension of detention. And I'm sure probably everyone in this panel or listening probably knows a good place to look for those, for some of those tips are the UNHCR detention guidelines, where they discuss ATDs and what should and should not be properly considered forms of those. I'll leave it at that. Thank you very much for inviting me to this really excellent panel. Appreciate it.
Thank you, Michael, for those words, because I think they are very important and definitely they are very provocative. And that's really what we wanted to spark today. What we wanted to spark today was a conversation, a reflection on all of those topics, an invitation of us all to question how we're using the terms and what strategies each of us is trying to move ahead in our particular context. Pablo, I would like to give you the chance to wrap up the panel.
Sí, gracias, Elena. Voy a tratar de ser muy breve porque sé que estamos pasados de tiempo. Dos cosas. La primera, repetir lo que decían mis colegas en respuesta a algunas de las preguntas, sobre todo de William, ¿no? Creo que el estándar global es la base para trabajar en esto, el derecho a la libertad, y hay una protección jurídica a nivel internacional muy clara en eso, que lamentablemente ha sufrido muchas regresiones, más profundas o no, en diferentes contextos, y eso es lo que hay que revertir. Y para eso están los mecanismos internacionales, regionales y nacionales de defensa de derechos humanos. Esa es la clave, es la guía, es la herramienta, es el objetivo. Luego, en el día a día, por estos contextos regionales y nacionales, las estrategias variarán en mayor profundidad, de acuerdo a los contextos, a las posibilidades, a los retos, a los cambios de escenarios, gestión de casos, alternativas, con la discusión que planteaba Mike, por supuesto, alternativas a la detención, otras estrategias, etcétera, etcétera. ¿Sí? Ahora, lo que quiero dejar como último comentario, porque para mí es fundamental, y esta es mi opinión, es que aún así, cuando hablamos de caso a caso, cuando hablamos de alternativas, estamos sentados en una mesa muy pequeña de discusión, y que la lente no es la adecuada. Estamos hablando de irregularidad solo con la lente de que eso es una infracción, la violación de una ley, y si respondo con una sanción, o con 2 o 3 sanciones de detención, deportación, o con un perdón, eventualmente, como una amnistía o un favor del Estado, cuando la irregularidad es mucho más compleja y tiene muchas otras dimensiones, y la gran mayoría de esas dimensiones no permiten atribuir la responsabilidad a la persona que está en situación irregular. No tiene ningún sentido que haya familias enteras, cientos de miles o millones en varios lugares del mundo, hace 10 o 20 años viviendo en situación irregular, y que no puedan salir de esa situación. Le aplicamos casi una mirada que se le aplica jurídicamente a los crímenes más graves que sanciona la Corte Penal Internacional. Son infracciones administrativas imprescriptibles. Yo digo provocativamente, infracción administrativa de lesa humanidad, porque nunca prescribe, ¿no? La persona no puede salir de esa situación, es un absurdo. Entonces, ¿cuál es la lente a la que hay que ir? Y ahí hay también muchos estándares internacionales, pero también mucho lenguaje del Pacto Mundial. Todo esto que los estados vienen diciendo hace muchos años, pero cada vez más en los últimos años, sobre política migratoria comprensiva, holística. ¿Qué es esto? Justamente que hay que abrir la mesa. La mesa no es solo discutir con agencias de seguridad o un ministerio de interior para ver si sancionamos o no privando de libertad a una persona. Hay que abrir esa mesa, hay que traer gobiernos locales, hay que traer autoridades de trabajo, de protección social, de desarrollo humano, de salud, de niñez, de género, etcétera, etcétera, etcétera. Cuando uno trae a esos actores a la mesa, la discusión ya no es infracción-sanción o infracción-perdón. La situación es cómo resolver la irregularidad migratoria, ¿sí? Y desde la visión del trabajo y del mercado de trabajo, no va a ser, lo voy a poner en una cárcel o en un centro de detención. No, bueno, ¿cómo mejoro mis indicadores en materia laboral, en desarrollo social, en desarrollo de la infancia, en desarrollo humano, en prevención del trabajo infantil, en prevención de la trata de personas, de la explotación sexual, de la violencia de género? Y así podríamos denominar una tras otra políticas públicas de los estados, que si los organismos a cargo las comunidades locales también, los gobiernos locales, estuvieran sentados en la mesa, las propuestas partirían de otra lente. Ni detención, ni alternativas a la detención, no. Inclusión social, formalización del empleo, protección laboral, desarrollo de la niñez, inclusión educativa, las discusiones básicas que tenemos que dar en cualquier sociedad, con o sin migrantes. No tendría por qué cambiar la lente que tenemos que usar para buscar las soluciones que tenemos en nuestra sociedad. Hay muchos ejemplos de eso, y hay oportunidades. El Pacto Mundial da oportunidades para dar esas discusiones que nos saca, de alguna manera, de esta mesa tan pequeña en la que nos han metido los discursos criminalizantes y que ven a la irregularidad migratoria como un problema, como una amenaza, que hay que responder únicamente desde la perspectiva de la seguridad y el orden público. No, tenemos que ir al corazón, como dice William. El corazón es social, es multidimensional, y es ahí donde hay que encontrar las soluciones con los actores adecuados. Va a haber muchos desafíos en fronteras, en muchos otros espacios, pero si logramos ampliar esa mesa, vamos a encontrar buena parte de las soluciones para muchos de estos problemas, y eso tal vez puede conducir incluso a abrir canales de migración regular que nos permita incluso resolver los problemas en contextos fronterizos, en rutas migratorias, etc. Gracias.
Muchas gracias, Pablo, por tus potentes palabras de cierre. I know we went 10 minutes over, but definitely those 10 minutes were worth it. And I'm really thankful to all of the panelists today, Sumita, Marta, Michael, Pablo, and Wayne, for your powerful words, your own experience, and the challenges that you're facing from where you're working on the ground. This was definitely a very engaging discussion, and this is the type of discussion that we want to provoke. The type of thoughtful process of really questioning ourselves, questioning the work we're doing, and not accepting or normalizing situations and policies as we have done for a long time. And that was precisely what this discussion about detention and deportation was hoping to be today. I want to thank all of you for being here today, and the audience for this very lively discussion. A number of documents were shared on the chat box. We are going to make those available on the website for this project, because this discussion does not end today. This was not only a webinar for the sake of a webinar, but what we're trying to do is to move forward a movement, to start the conversations, and definitely that's what we did today. We will continue. We hope to bring some of you again, perhaps from other sessions, and also to be able to bring other voices, other realities and examples from other countries and other regions that unfortunately we were not able to have today. Thank you everyone for this powerful conversation, and we hope to see you again in 1 week about a very important topic, which is climate change and migration. Thank you everyone. Have a very good day or a very good evening.
Thank you very much.
Thank you. Thank you.
Thank you very much.
Thank you.
Thank you very much.
Thanks.